What is guardianship? Hello, my name is Tim McCurdy, and I am a guardianship lawyer practicing in St. Louis, Missouri. Do you have a loved one who is struggling with dementia? Do you have a special needs child who is turning 18 and will now be considered an adult? Is there a child whose parents are no longer able to care for that child? If one of these circumstances applies to you, then guardianship may be necessary to help protect your loved one. So what is guardianship? Guardianship is the process where a judge appoints someone to make decisions for someone else. And this can be for an adult when the court decides that that person is incapacitated. Or it can be for a child if the court determines that the child's parents are not able to fill their role as the natural guardians for that child. Guardianship proceeding is one of the most significant things that a court can do. In a guardianship, before someone can be appointed to make decisions for someone, the court must also decide that the individual is unable to make decisions for him or herself. So that can mean, for an adult, taking away that person's right to make decisions for him or herself. For a child, that can mean taking away the rights of a parent to make decisions for the child. Because guardianship is so significant, there are a lot of procedural protections in place to make sure that before a judge enters a guardianship and takes away those rights, that it is absolutely necessary and it is the best decision for the interests of the person who needs the guardian. Those protections are going to include notice to different individuals so that they're aware of the guardianship proceeding and give them a right to come to court to express their views on whether the guardianship is necessary and who should be guardian. For an adult, there's going to be a mental and or physical evaluation to say from a medical standpoint that a person is incapacitated and needs a guardianship. Before someone will be appointed guardian, oftentimes there will be certain background checks that must be performed. And if it's a child, there may be a home suitability study done to make sure that the child can live there safely. And also there can be a guardian ad litem appointed who is an attorney that will evaluate the circumstances and report back to the court on whether or not a guardianship is necessary. Now, because all these protections are in place, there are numerous hurdles that have to be overcome before a guardianship can be entered. And we also talk about the difference between guardianship and conservatorship. In Missouri, we break down the functions of an individual into the guardianship of the person and conservatorship over the estate. And what we're really talking about there is the guardian will make decisions about where the person will live, their medical treatment, things of that nature, whereas the conservatorship only applies to manage the finances of that person. So if someone who needs a guardianship also owns property, they have bank accounts, they have investment accounts that need managed, then a conservatorship may be appointed to manage those finances. And also, what are the powers of a guardian? And those can be very broad and expansive. When the court is appointing a guardian, the court is also saying that that individual can no longer make decisions for him or herself, or the parents can no longer make decisions for the child. So if it is what we call a full guardianship or unlimited guardianship, then the guardian can make decisions on behalf of that person as if they were that person, essentially, or for the child as if they were the parents of the child. So that can include deciding where the person is going to live. It can include making decisions about medical treatment and consenting to medical treatment. For a child, it could decide where that child is going to go to school and much more. If it is a full guardianship, the guardian can essentially make decisions as if it was that person or that child's parents making those decisions. Now, guardianship can also be limited, and that can be tied to the circumstances for that individual, to where the court is tailoring the powers of the guardian, because the goal is that, if possible, the individual who has been found perhaps partially incapacitated can still make some decisions on his or her own. The court is going to do everything they can to allow that person to still be involved in that process. So perhaps there are certain things that individual can do so they can still make certain decisions, but then the guardian will be appointed for everything else. So in those cases, the powers of the guardian will be carefully set out, and then the scope of the powers of the guardian will be limited by that limited power of attorney. Hope you found this information to be useful. Please keep in mind that this is general information and should not be used to base your own legal decisions upon. If you have questions about guardianship, I'd be happy to speak with you about those and answer them. If I can, please feel free to contact me. Thank you.